On the home stretch, some stakeholders have been reacting to the recent statements of the Chief Justice of Nigeria, warning legal practitioners to desist from uttering unguarded statements on pending court cases. We have a few of such reactions.
Well, the CJN is just to, the comment, I see it as an intention to uphold the rule of law, and it is not fair for lawyers to come out of court or to take over proceedings that is going on before the court and start giving opinion, expressing view, and making comment on a case that is pending in court. It amounted to a contempt of court for you to be discussing the live issue to the press. It's different from the fact that if we come out from the court and you ask the lawyer what happened today, where we call two witnesses and we leave it to the court. That's all. It's not for you to continue to evaluate the evidence of what that witness say in the press. It is not for you to give opinion of what the judge is going to, or anticipate the opinion of the court. That is not the duty of the law of any lawyer. So the CJN is very right when he said it's a contempt of court for you to be discussing the proceedings of the court. It's not allowed under any other law. It's a contempt.
The position of the law is that when matters are being adjudicated by courts of law, we should allow the courts properly adjudicate on those matters and come up with a conclusion one way or the other. Where those matters have been concluded and judgments given, and there is no appeal on them, parties could make intellectual comments, give opinions. But when there are live cases being handled by judges, I think it's wrong for lawyers to be drawing conclusions, making comments that could impugn negatively on the administration of justice. And of course, where you make such kind of comments, particularly unguarded ones, in some instances, it could be seen as an interference with the administration of justice. And to a large extent, that could be contemptuous. The line is very thin. I think so lawyers should just be very careful and just stay clear. Where individuals who are not trained in the legal science make these comments, then to some extent, after some warnings, the full weight of the law could be brought to bear on such. But when it comes to common lawyers who actually should know, are expected to know, I think we should be very careful so that we don't create parallel courts. You have courts hearing matters, adjudicating over matters, in some instances, sensitive matters. And you have media trials and media conclusions and media judgments. And where you have all these comments, you have media judgments and actual judgments, who do you appeal to? There's no appeal on media judgments.
I think the CJN is totally right, because most of them come outside the court and interpret another thing entirely to the society. Come, the rules of the court that is within the four corners of the court. You should not come out and be expressing yourself the way you cannot even express yourself inside the court. It's abnormal. I think it's the right time for CJN to take a radical action against some lawyers who come out of the court to come and interpret wrongly in order to impress the client. Also, we need to blame the journalists, especially both the media and the electronics, who one way or the other give them the opportunity. So far you are in the court, you don't need to ask them the same question. You are there to report what is in the court, not outside the court. So that is it. I think the CJN should do proper thing for the lawyers, if possible for the journalists.
And that's our program today. Please feel free to share your views with us on any of the issues we discussed on the program today. If you missed any part of it, you can find it in past episodes on our YouTube channel. I'm Shola Shieli. Thank you for watching.